Good morning, everyone. Welcome to House Judiciary. We have two bills we're going to consider this morning, House Bill 43 and House Bill 53. Just a few ideas and thoughts in terms of our decorum. It's critically important that we maintain decorum in the committee. We can have civil discourse, polite. We're going to let folks talk and share their opinions. But we're not going to argue. We're not going to get into shouting matches. We're going to maintain our decorum as this body deserves. And I ask everyone to silence your cell phones, make sure we don't have any phones ringing in the middle of this event. It's also really important that when you testify that you bring all comments through the chair and not directly to individual legislators or to other people in the room, okay? We keep it all through the chair. And with that, Pierre, why don't you call the roll?
Representative Brady?
Here.
Representative Brett?
Here.
Representative Chestek?
Here.
Representative Filer?
Here.
Representative Kelly?
Here.
Representative Lean?
Here.
Representative Singh?
Here.
Representative Webb?
Here.
Chairman Washet?
Here.
You have a quorum.
Thank you. All right. So our first bill this morning, House Bill 43, age verification for websites with harmful material. Presenting the bill this morning will be Representative Lawley. Welcome, and please tell us what you want us to know.
Good morning, Mr. Chairman, and thank you. Good morning, committee. It's good to be before you. It's my pleasure to present to you House Bill 43. I think it's an important bill, and it's something that I've heard a lot about from my constituents, and I ask for your favorable consideration. Mr. Chairman, I have long been concerned, like many of you, about the safety of children online. I want to make sure Wyoming is doing all it can to protect children from online pornography. The pornography industry employs sophisticated tactics to target children. They use pop-up ads, misleading links, and enticing visuals. And it's designed to lure children into watching explicit material. Our kids are being targeted. This age verification requirements, using age verification requirements would prevent children's exposure to pornography online. House Bill 43 requires internet sites that publish pornographic materials to provide age verification for access to their site, and it provides effective and significant remedies for violations. This is very important that we have remedies that will work. And Mr. Chairman, here's what the research shows. The average age of first exposure to pornography is between 7 and 13 years old. By the age of 17, about 75% of adolescents have been exposed to pornography. 58% of individuals exposed to pornography for the first time accessed the material unintentionally. 88% of pornographic videos depict sexual violence, while 48% of these same videos include some kind of verbal abuse. Mr. Chairman, there's a strong correlation between pornography, human trafficking, and sexual abuse. Sex trafficking is the supply side of the pornography industry. You're going to hear more about that today. Studies reveal that pornography has the same effect on the brain as drugs. Porn is as dangerous as hard drugs or opioids. Age verification requirements would prevent the unintentional exposure and reduce overall underage exposure to pornography. With that, Mr. Chairman, I'd go through the bill with the committee. This bill starts with a lot of definitions, and they're important because we're dealing with a subject that there's importance that there be explicit and good definitions with what we're doing to provide protections. So we have a definition of what a covered platform is. Well, first of all, on page 2, we start with the definitions, and some of these are what you would kind of expect. But I want to point out that we are using, down on page 2, lines 21 and 22, we are beginning to pull out some definitions we already have in statute. So again, not to create confusion, to try to use someone else's definition. So these definitions already exist. For example, on page 2, line 21 and 22, child pornography means as defined in Wyoming Statute 6-4-303, A, Romanet 2. And then on the next page, we have a covered platform. This is, again, a definition that we're using for the covered platform, and it helps you understand that what websites are included and covered underneath the requirements of this law. I want to go down to a couple of other definitions and point them out. On page 3, lines 16 through 22, this definition comes from an existing federal statute, and that statute is 47 U.S.C. section 230F. One option we had was to just cite that statute, but that statute could change in a way that we might not agree with. And so instead of, I just used the definition from that statute, wanted you to know where it came from, but it comes from a currently existing federal statutes. On page 4, the next definition, information content provider, is also a definition from existing federal statutes. This is the definition comes from 47 U.S.C. section 203F. Then you'll see, again on page 4, another definition that we just referred to current state statute. So again, the definition of obscene comes from a current state statute, and then down on, as we get into the verification measures, how you can verify, what you can use to verify age. The first one involves driver's license, and again, we're citing our state statute on our definition of driver's license. I think, again, most of the other definitions are fairly self-explanatory. So if we want to move on to page 6, we get kind of into the meat of this. Again, a covered platform shall perform and shall prevent access. That's the most important thing in that paragraph. And that it's, of course, to this harmful material. They shall perform and they shall prevent access. This is their obligation under this bill, their obligation under the law. No matter what happens, if it gets diverted by someone else, republished by someone else, these original covered sites they're liable for that under this statute. And it's important in the age in which we live, in which something can be republished and spread through an app or other things, but it does not change the liability for the source. And we're going to the source of the problem in this bill. And it talks also about B, under section B, another very important point in terms of privacy protections. These covered sites or third parties that perform the required age, I can't get that word out today. Age verification shall not retain any of the identifying information of the person after access has been granted to the material. So we are going to provide some protections in that in terms of some private rights of action and redress if that happens. So it's very clear they are not to do it, and we'll see later in the section where we go through some of the remedies. As we begin with the liabilities and limitations here at the bottom of page 6, it says a parent or guardian shall have a cause of action. So again, that's just as we're setting up the remedies, parents, guardians can pursue actions. So we go on to on page 7, as we look at, I think section B is probably where I'd point out next. There's a cause of action created for knowingly retaining identifying information. So again, back to that shall not earlier, this is remedy that people have if that were to happen, if they were not to do that. Under C, it kind of gets into the specifics of some damages. So for attorney's fees, actual damages, can be pursued for those violations. And then we go down to page 7, paragraph D, is again liability for damage and attorney's fees for retaining identifying information. So extensive amounts of ways and options in terms of remedies if something, they don't follow the statute. In that case, again, not for keeping private information in that case. So you go on to page 8, and again, we're still talking about remedies, causes of action, what happens when they don't do what they're told they should do in the statute. So one of the things that can happen is this, in this situation, is the harm can occur and occur and occur and occur by each situation. So just what's addressed in paragraph E on page 8 at the top is this idea that each of those additional incidents of violation, you can get additional relief. So then we get into, in paragraph F, you can still get damages if part of the act is declared unconstitutional. And that's, again, more a legal thing that basically says they can declare part of this unconstitutional, but it will not affect your right to a remedy on either the side of exposure, this thou shalt not allow the harmful material without age verification, or on the keeping of any identifying information. So both of those shall nots are covered. And then G is that it's got a lot of interesting legal language in it, but it basically talks about, and this goes back to the fact that the harm can keep occurring. That if, let's say that they did not follow this and you sued them for that, and you received some kind of relief in that lawsuit, and then there was another harm after that. This is making it very clear that that previous lawsuit does not block you from pursuing the subsequent harm. It's kind of important to do that because it gets kind of confusing for courts sometimes, and to say that in a way you're prohibited because you filed the suit already, you got relief. But this is making it very clear because we know the damage is something that can occur and reoccur. And so that's for the courts to know. We're specifically making a policy decision here in Wyoming that knowing how the harm can reoccur and reoccur and reoccur, that previous lawsuits will not on its own stop you from filing for subsequent harm for the same thing. Then on page 7, there again, cause of actions for the, we already did that, I'm sorry, I turned my page the wrong way. Let's go on to page 9, and then this is something that is really important to know and maybe explain a little bit why. On page 9, we have a statement that says, starting in line 2, violations of this statute shall be enforced exclusively through civil actions as provided in this section. And so everything we're going to be talking about here that are the actions that relate to the harm that comes from not complying with the statute are civil in nature. And that's a choice. It's a policy decision. And the reason that it's written this way is because it addresses some potential constitutional concerns that the government, we're not using the force of the government to enforce this statute. We could have the Attorney General relief be involved, and if the law develops in a certain way, we might do that later if we wanted to. But for those of you that are concerned about, is the law, this bill does not, in fact, it kind of excludes the actions by the government. It says these are the only actions, private causes of action against those who brought the harm, which is those who are those ones mentioned and defined in here as distributing that harmful information. Does that make sense? I just hope the committee understands that's a policy decision. I know you can read and you can read what it says, but I want you to know what the implications are, and I think they're important, and this is the best choice for now in the state of the law, that we only include private causes of action. And then you can go and see there that no direct or indirect enforcement of this article shall be taken or threatened by any state or any political subdivision of the state against any person, except as provided in this section. So we've actually made it kind of doubly clear that our goal is to provide private causes of action for people to go to proceed with the violation. So there's another something in here that again is a policy decision, partly a policy decision, I would say, is on page 10, lines 20 to 23. It specifically tells us that this does not apply to search engines. That question has come up to me. It was a really great question, but the plain language of the bill is just saying that that's not what we're targeting. We're targeting the source of the harmful material, and for them to have a clear mandate to not expose children through the use of age verification, and then provide, again, significant remedies. So I wanted to point that out to you. I think that's about it. It's effective July 1, 2025, but Mr. Chairman, I will just say this, that there's always some issues when you're dealing with something like this that raise some potential First Amendment concerns. The bill was constructed really around some of those issues, and I feel confident in saying this. House Bill 43 is legally defensible under current law. There's already an exception to the First Amendment for obscene content. There's already an exception that exists and has for a long time. Recently, the Fifth Circuit upheld the Texas age verification law. And then we also have Louisiana, and we have Utah that have laws. They were sued, but both of those suits were dismissed at the district court level. So I believe this is legally defensible language, written intentionally to not get in the way of any constitutional protections. It was written strongly to go right to the source. And the remedies are significant and meaningful. And with that, Mr. Chairman, I'd stand for any questions.
Thank you, Representative Lawley. So as we proceed with this, the sponsor is given a fairly liberal amount of time to present the bill. All other witnesses are asked to be very concise in your answers and responses and your testimony, because time is of the essence. We have another bill yet to be heard this morning. So committee, any questions for Representative Kelly?
Thank you, Mr. Chairman. Thank you for being here and for your deference to Amendment 1. First, I just want to make a quick statement. I take exception with the idea of likening pornography addiction to opioids, considering no one's ever died from accidentally clicking on a link, but that has happened with pills. Not to downplay the seriousness of this issue, but I don't want to downplay the seriousness of things like fentanyl on the streets either. That being said, I have a question here about what we call material harmful to minors. Means any picture, image, graphic image. We're on page 4, lines 6 through 9. Any picture, image, graphic, image file, film, videotape, other visual depiction that is obscene or is child pornography. Child pornography is already illegal at the federal level. Is this not inadvertently creating an age verification loophole for child pornography? Because it says you can't access these types of materials unless you verify your age, and child pornography is one of the things listed you could access if you verify your age, because I'd rather that's not available regardless of someone's age.
Representative Lawley.
Thank you, Mr. Chairman. No, I don't believe that's what this provision does, but, and the fact that child pornography is illegal is different than the fact that child pornography still exists. And so that's why it's included in the definitions. And so I don't believe that it creates that kind of a problem at all. Thank you for your question.
Further question, Vice Chairman.
Thank you, Mr. Chairman, and thank you, Representative Lawley, for bringing this bill. I do have a question about how would this bill interact with individuals? We passed House Bill 7 in 2023, and that addressed folks that, people that were 16 were able to get married with the consent of a judge and their parents. So would, minors be able to, who were already married under Wyoming law, would they be prohibited from accessing this material as well?
Representative Lawley.
Thank you, Mr. Chairman. Representative Singh, the state has an interest in setting ages differently for different circumstances. So this one is 18, and there's nothing unusual about a state having some different ages for different activities. So yes, under the statute, the age verification is basically to age 18 or over. So there's a distinction there, but that's not unusual, would be my response to that.
Further, Representative Shusty.
Thank you, Mr. Chairman. I have a series of questions. I apologize that being a lawyer on this committee, I have some.
One at a time.
Yeah, I'll do them one at a time for sure. But there's a series of them. And first of all, I wanted to echo my colleague, Senator Representative Kelly. I got the name right that time, I think. That this does appear to me to create a loophole for adults who want to access this material. The remedy here is if a minor accesses it, you can sue, but if an adult accesses, you can't. I understand that accessing child pornography is a crime for anybody, right? And the adult who accesses it can be charged with a crime, and those crimes are frequently prosecuted, and frequently people go to jail for a long time for violating the statute, for the criminal statute. This creates a civil remedy, so it's a different bill, I understand that. But how does it, what problem is it solving? Is it, why, if an adult accesses it, why shouldn't you be able to sue for that as well? Because it's still illegal.
Representative Lawley.
Thank you, Mr. Chairman. Representative Chestic, I appreciate that you have a lot of questions. I always do too. So just to say that I get you. I understand that. So, but I think you hit on the answer yourself. We're talking about civil remedies here, not criminal remedies. Those still exist and they're still intact. But there is undeniably an explosion of child porn right now, even though it's currently illegal. I mean, it is actually, I believe, one of the fastest growing areas, and the use of AI particularly to create child porn. So we can't say it's not a problem. And to exclude it from the definition would be a loophole the other direction. But that does nothing to interfere with the prosecution of those who create and distribute child pornography. These are civil remedies. That's my answer on that.
Representative Shusty.
Thank you, Representative Lawley. Another question for you. You say that the purpose of this bill is to prevent unintentional exposure. I totally am board with what you're trying to do. I think it's a great thing that you were trying to do, and I agree with the goal, but does this bill do that? And I have questions about whether this bill does it. What this bill does, first of all, let's start from the premise that any website, you're targeting the websites that distribute this material. Isn't that illegal? The website itself is illegal, so are they going to follow this? Because they're already criminals by doing this. Are they going to follow this law anyway? But the point is, you say you're going to require these websites to engage in reasonable age verification measures. So that sounds like you're going to ask anybody who goes to that website must prove that they're an adult, right? How does that get to the problem of unintentional exposure? Somebody who's trying to log on to that website intends to look at that website, so this doesn't address unintentional exposure at all. How does this deal with unintentional exposure?
Representative Lawley.
Thank you, Mr. Chairman. Representative Cheswick, first of all, there's two goals here. There's unintended consequence, or what I call an unintentional exposure, that they're brought in through some sort of method and they click on something and it's unintentional. But there is also an element of this, as I mentioned earlier in my remarks, about any underage use of these porn sites. Because one of the issues is once they get hooked on a link, through a link or onto these sites, some of them begin to be drawn to these sites. And then it's no longer unintentional, accidental. It does become that. So we're covering both of those, first of all. The effectiveness of this remedy, I'm going to defer in a moment here to my colleague or friend here, our expert on the technology, Ian Corby. But before I do that, I can tell you that states where they have enacted this, the porn industry left the state. They left the state. So, is it effective one way or another? I think it will become effective. And if it's not effective enough, we can come back in and do some more on the remedy side. But it is effective, and you're going to hear from, and the reason I want to defer to Ian Corby here is that they have been doing this for several years in Europe. They don't have a First Amendment, so they've been working on this issue of children's accessing pornography, and they are way ahead of us in terms of recognizing the importance of this issue and doing something about it. So, Mr. Chairman.
Mr. Corby, welcome this morning. Again, keep your answers brief and on point.
Thank you, Mr. Chairman, and thank you to the committee for allowing me to speak briefly this morning. I represent 30 providers of the technology that allows you to prove your age online without disclosing your identity. So if I may, I'll in 60 seconds give you 60 ways of doing that. Sorry, 6 ways of doing that. 60 would be ambitious. So the first one is what you might expect. You have your ID, you take a photograph of that with your phone, you take a selfie. We check that both the ID and the selfie are real, that you're not a fake from AI generated. We compare the two, and if they match, we can check your age. And the only thing we share with the adult site is the fact that you are over 18, yes or no. No personal data is sent, and as the representative said earlier, all that data must immediately be deleted once you've completed that process. We can do that with a digital ID. Many states are introducing mobile driver's licenses. I believe you may have one of those coming up at some point here. You can selectively simply release your age through that. But we have some other innovative ways of doing it as well. You may have used your email address to check mortgage interest rates recently. You might have done that and given a cell phone number in the same process. Well, those are not typically things that children do. If you've done 100 of those things as an adult with your email address or your cell phone number, then there's a pretty reasonable expectation that you're an adult. And so by asking you to give us one of those two things, checking you're in control of the inbox or of the phone, we know that you're an adult. There's even one organisation which can tell by how you move your fingers. So you just hold those up in front of the camera and make certain movements, whether or not you're over 18 with 99% or better certainty. The most widely used estimation system is facial age estimation, where again, a quick selfie and we can tell within 1 or 2 years your actual age. Obviously that's no good if yesterday was your 18th birthday, but if you're as long in the tooth as me and you're estimated to be 50, there's really very, very little chance that you're actually under 18. So this works really well for most of the population. I was at the Supreme Court last week where they were listening to arguments on this very topic. They decided 20 years ago that we should use filtering as a less burdensome method. I think we've got 20 years experience now of looking at filtering and seeing that kids are now seeing far more pornography than ever before. And the discussion, of course, we don't know the result of the Supreme Court yet, but the discussion was as long as legislatures have put on the record that they've looked at the alternatives they're suggesting and that they are not unduly burdensome, and I hope those 6 methods don't sound too burdensome to you, then it is a legitimate thing, even applying strict scrutiny to the First Amendment, for you to decide that people ought to go through that process. I'll be very happy to answer further questions.
All right. Let me see if there's any other committee members to give them a bite at the apple. Anybody else have a question before Representative Shostak, please continue.
Thank you, Mr. Chairman. I don't mean to dominate here, but this is an important bill, and we need to get the details right. And I have several more questions, but in the interest of time, I'll just ask one more question. And this one gets into the weeds pretty deep, and it's a question only a lawyer can love. So, but it's our job to get into the weeds. This is a bill that's going to be on the books. It's going to be in the green books. It's going to be enforceable. And my question deals with, on page 8, paragraph G, that weird legal language that you were referring to earlier. I have some questions about that weird legal language. I know what issue preclusion is. I know what claim preclusion is. I'm not sure what non-mutual means, so that's my first problem. But my second problem with it is this. I don't think this is necessary if you have E. E is fine, I have no problem with E, but so issue preclusion and claim preclusion are res judicata and collateral estoppel, more legal jargon, right?
Correct.
But you and I understand it. But what that basically does is it preserves finality of judgments. So when a judgment is entered, you can't relitigate it. That's the whole point of issue preclusion and claim preclusion. What this says is if I file suit against an internet provider and I lose, I can sue them again because there's no more issue preclusion or claim preclusion. And if I lose the second time, I sue them again. And it goes on and on and on. So I don't know why we need to create a Lawyers Full Employment Act here. Even though I don't mind lawyers having employment, I think I don't understand the purpose of this. When you have under E, every new instance, every new exposure is a new claim. It's not precluded. So you don't need to allow the same claim to be relitigated over and over again. What is the purpose of Section G?
Representative Lawley.
Thank you, Mr. Chairman. Representative Chestic, because of the unique nature of the dynamics of this situation, you have, again, some initial harm, and then you can have some ongoing harm. And there are situations where courts will determine that you've already been addressed, it's already been addressed. And so, again, I think it's an additional protection under the circumstances of this harm that can continue on, and I just think it's an important protection in there. I don't think it necessarily continues to employ lawyers, but I definitely respect your opinion about that.
Further questions? Representative Vice Chair.
Thank you, Mr. Chairman. Representative Lawley, so during the session, we're having a lot of conversations about voting and how folks don't want to defer the process of voting to a third party via some sort of voting machine. Does this bill have any sort of provision to ensure that third party applications or entities that are getting this information are actually doing a valid job?
Representative Lawley.
Thank you, Mr. Chairman. Representative Singh, there are provisions within this bill that specifically goes to those who are the third parties and their liability, and very, very clear consequences of what the liabilities put on them as far as personal information or identity. So yes, it's in there. That's part of the process and the protections of the bill. And it specifically has provisions in the bill concerning these third-party providers.
So Representative Lawley, on that point, it puts the onus on the material provider to make sure that their service provider for identification is compliant. And if they fail, they're the ones who suffer. So it puts the onus on them, correct?
Mr. Chairman, that is true but we also have provisions specifically for individuals who might be harmed by the third-party provider not complying with this bill, that you can actually have private cause of action directly to that third-party provider. So there's both. There's both to protect the privacy.
Further questions? Representative Lane.
Thank you, Mr. Chairman. Thank you for coming today. This might be for your counterpart, I'm sorry, Mr. Kirby, was it? Quigley. So my question is, as you've participated in other states and helping them implement this process, what have you seen as far as a reduction in pornography usage?
Mr. Corby.
Thank you, Mr. Chairman. So what you will hear, a statistic quoted by ALO, or Ethical Capital Partners, who are the owners of Pornhub now, is that 80% of the users in Louisiana stopped accessing their website when they introduced age verification. What they mean more accurately is 80% of users with an IP address which is registered in Louisiana stopped accessing, because a number of people would have used virtual private networks, which is a way of pretending you're in a state that you're not currently in order to continue to access those sites. But what Representative Lawley's bill does very cleverly is make sure that the websites are still responsible to keep children in Wyoming off their sites, however those kids access the internet. So whether or not they do it directly with a VPN or using paper cups and a piece of string, you still have to keep those kids off the adult sites if they're located in Wyoming. So I don't really accept some of the statistics that say there was a massive fall off in access. And some people may think that's a good thing anyway, but people do still access. And I don't mean to disagree with you, but a very large number of adult sites have introduced age verification. Our members are providing that service. It costs those sites maybe 12 cents per user per year. That's a UK government estimate, and they expect that to come down, and I would agree that price would come down because they've just chosen to comply. And in fact, they don't want kids seeing their material. Bear in mind, most people don't pay for this, and children certainly can't pay for it. So they're not great members of their audience either. So it's not necessarily the entire adult industry that opposes this initiative.
Further questions? All right, we're at 8:35. I'm sure there's some other folks interested in testifying in the room. Thank you, Representative Lawley. Please stay close. There might be some follow-up questions when we're done.
Okay, Mr. Chairman, too, I'm going to stay as long as I can, but I have a bill over in Labor and Health also.
Lucky you.
It is my lucky day.
All right. So anyone in the room wishing to testify on House Bill 43? Thank you for coming today. As I said earlier, time is always of the essence. Please keep your comments brief and on point.
Good morning, Mr. Chairman and members of the committee. Thank you very much for this opportunity. My name is Steve Amelia. To be succinct, I am fully in support of this bill, and the reason is because for 30 years I've been in public health, which has dealt partially here with a lot of sexually transmitted diseases, which means people have to be into that type of activity. And it also gets into children being exposed to pornography and that sort of stuff. So I was standing in support of this bill. This is harmful to adults because it objectifies people. And if we have this much problem in our adult society with sexual harassment, sexual violence, and et cetera, seeing men and women back and forth is not people. I mean, I really have to look at all of you, especially the ladies, because I'm a guy. I have to look at you as a person. I can't look at you as some sort of object that would be insulting to you, insulting to me. And to expose our children to this is harmful also. And I would go back to Representative Kelly, what he mentioned, not to downplay how drugs are addictive. I know professionally throughout my career, the addictive behavior of pornography, once you see something, you can't unsee it. So without going over and rehashing a lot of stuff, I'm fully in support of this bill. Thank you very much.
Thank you very much.
Good morning, Mr. Chairman, members of the committee. My name is Greg Hunter. I'm from Laramie, Wyoming. When I first saw what I think the word is these covered sites, I was pleased because finally, the parents would have to actually discuss sex education with their children. That's what I saw when I saw these particular sites. The era that I grew up in, sexual expression was suppressed due to religious issues. I was a Southern Baptist, so the idea of sex was frowned upon, and you could not get any information from adults. There was the ability to, I ended up getting a lot of sexual material by dumpster diving. We ended up getting a lot of.
Can we stay on the bill, please?
Well, I consider these things sexual instruction and not necessarily harmful material. What I see is that this will now put people back into registering and then grooming people based on that. The first sexual instruction film I ever saw was presented to me by an older gentleman. There was about 8 of us. This gentleman named Ralph, he used to run the Kettering Rent-A-Kid program. And so we went over to his house to watch what was called a stag film in our day. And I definitely remember watching the film, and then I went to the restroom and locked the door. And I can remember him coming to the door and shaking on it, go, "You don't have to lock the door in my house." And I go, "Obviously I do." And so these kinds of bills now, instead of parents taking responsibility to teach their children about sex and understand the benefits of sexual release, including masturbation, because once I stumbled upon masturbation, I felt like I made much better decisions in my life. I did better at school. I wasn't as aggressive with the female population. I also recognize, based on reading this particular bill, that I actually conducted, based on the bill that is being brought by Representative Heiner and backed by Representative Lawley, that I engaged in prostitution, basically, because I had sexual.
Stay on this bill, not the other bill.
Well, the intimate parts bill is referenced in this particular bill, and the intimate parts, when sexual release occurs through clothing and masturbation occurs, if I had not stumbled on masturbation, I feel like that I would have made poorer decisions and I could have been groomed in a lot more manner. So this age verification means you don't know who these people are. They are now grooming our children with these bills instead of parents taking responsibility to teach sex education like they should. So I'm opposed to this bill, and everybody should be. One more thing about the age verification.
Sir, a lot of other people. Keep it brief.
Okay, I'm going to say one more thing. I was in Texas, and yes, you cannot access these covered platforms, but you didn't need to, because Twitter had gone full First Amendment, and there were entire what I would consider sexual instruction videos up on Twitter in Texas at the entire time. So there are plenty of loopholes. In other words, Texas should make sure that anybody that gets on Twitter has age verification. So again, we are creating a position where groomers will get it and groom our children because they do a terrible job at sex education. Thank you very much. Have a good one.
Sir?
No questions?
Chairman, members of the committee, my name's Joseph Martinez. I'm from Fremont County. I'm not very good at speaking right off the top of my head, so I have written some notes down, if you don't mind me reading from those.
As long as they're brief.
Yes, sir. House Bill 43, I'll take a lot of my time to address, I think, the concerns of people who might be opposed to this bill, not so much in support of it, because I think that it might be kind of obvious why we should try to protect our children. House Bill 43 is not about censorship or undue regulation. It's about protecting the mental health of children and of minors in Wyoming. It's a moral imperative to act, ensuring that minors are shielded from exposure of damaging materials while respecting the rights of adults and maintaining privacy. One concern is, will this bill actually protect minors? And I would say it absolutely does. Currently, it's very easy for children to access pornography online. Usually you can just search up the word if you're curious, and then you can go to a website and it's one click from there. No verification is conducted because it's just one click. Research consistently shows that early exposure to explicit material negatively impacts minors, distorting their understanding of relationship, body image, and consent with others. The American College of Pediatricians notes that such exposure is associated with increased rates of depression, anxiety, acting out, and violent behavior. So we should try to prevent this from taking over our children's health. This bill directly addresses concerns by reducing the likelihood of unintentional or deliberate access to such content. Another concern is, does this bill violate privacy? And I would thank the good man who testified earlier that there are many different ways for age verification to happen, and this bill specifically says that it cannot hold on to the data received by the providers, verifying the age. And then, the morality of inaction, I already expressed why this type of content is harmful to minors, and it is affecting a lot of minors. If we don't do anything about it, we're allowing this to continue. And I think if we don't act, if you guys don't act, it will continue. Another issue I want to address is that pornography particularly affects boys and young men. We know that children's mental health right now is struggling across the country, largely due to technology, and you access this material through technology. Parents cannot always monitor their children's activity if they don't want them seeing this content. And even if they did want them to see this content, they could do it by verification themselves. I don't agree with that, but I believe in the First Amendment. If you want your kids to access that you can, but this prevents it from even unintentionally accessing it. If the parents don't want them to access it through, some kind of restriction on their Wi-Fi or on their phone, they could potentially get that information from a friend's phone or from a different Wi-Fi source. This will help parents raise their children. We would never really allow this type of negligence in physical spaces. So why should we allow it online? And then I do have a few concerns with the bill. One thing is the definition of obscene, and excuse me if I forget the vernacular wrong, but Section 6-301 definitions, obscene is one of the definitions of obscene is taken as a whole, lacks serious literary, artistic, and political or scientific value. I'm not sure if we should be preventing that, children from we should not restrict children from accessing that because, sometimes there's entertainment value or social value. But obscene says, taken as a whole, lacks serious literary, artistic, political, or scientific value. So maybe change the word from obscene to sexual, the definition of obscene to the definition of sexual conduct, for example. I don't know. You guys are a lot smarter than I am about that issue. There was one other thing. No, that's it. I think that was already covered by a previous
All
speaker.
right. Thank you so much for being here and testifying this morning.
Thank you, gentlemen and ladies.
Before we have Mr. Winter, let's check a couple people on Zoom. I have a tendency to forget those folks and, okay. Okay. Whichever signed up first, let's get them in. Okay. Mr. Saldivar, are you there? Good morning. Please introduce
Mr.
yourself
Chairman.
for the record and be very brief, but tell us what we need to know.
Thank you, Mr. Chairman. My name is Conrado Saldivar, and I'm here on behalf of the Wyoming Library Association. I'd like to address some of our concerns regarding HB 43 and its potential impacts on library services across the state. WLA supports protecting children online, but opposes HB 43 due to its unintended consequences for covered platforms, including those offered by libraries. These platforms, such as Overdrive, statewide databases, and institution-specific resources, serve all Wyoming residents from K through 12 students to university students and the general public. The bill's definitions mean that platforms with vast collections, such as Overdrive's 79,000 digital titles or databases with hundreds of thousands of articles, would need to implement age verification. This is not only logistically daunting, but risks over-restricting content for all minors and adults due to fear of legal repercussions. Libraries tasked with ensuring open access to information could face significant burdens managing compliance while also restricting protected speech. WLA also notes the legal challenges surrounding similar legislation. The aforementioned Texas bill was heard at the Supreme Court last Wednesday and is still pending a decision. Passing HB 43 amid such legal uncertainty raises serious First Amendment concerns. To close, HB 43 risks creating significant barriers to information access while posing constitutional challenges. WLA urges the committee to carefully reconsider the bill's broader implications. To refer to something said earlier, the purpose of the bill is to go after the source of the content. Unfortunately, libraries and access to information would be affected in doing so. Thank you for your time.
Thank you. Very helpful. Appreciate that. And we have one more on Zoom, Ms. Barco, is that what you said? Okay, let's go to Ruthie Barco first. And good morning, Ms. Barco. You're on mute.
Can you hear me now, Mr. Chairman?
We can hear you now. Please introduce yourself for the record and be very brief, but tell us what you'd like us to know.
Thank you, Mr. Chairman. My name is Ruthie Barco. I am the Executive Director for TechNet Central Region, which includes the great state of Wyoming. TechNet is the national bipartisan network of technology CEOs and senior executives. We promote the growth of the innovation economy, and our membership ranges from startup companies to some of the most iconic companies on the planet. We represent over 4.5 million employees and countless customers in IT, artificial intelligence, e-commerce, transportation, fintech, and more. My comments will be brief. I am testifying today on House Bill 43 simply because we have just a few clarified amendments that we will be offering on the bill. These amendments ensure that other commercial entities outside of those that knowingly publish or distribute material harmful to minors on the internet could not be incorrectly found liable for damages under this law or incorrectly interpreted to fall under its purview. We will submit this language to the sponsor. We reached out to Representative Lawley, albeit on a very short timeline before this committee hearing, so we apologize for not having that language ready, but we look forward to working with the sponsor on this bill. We recognize that the drafting is intended to accomplish an appropriate scoping of this bill, and we appreciate that approach and the sponsor's work on this, and only have a couple of key changes to offer, including adopting the generally used standard of a 33 1/3% threshold of content. This aligns House Bill 43 with the Louisiana and the Utah bills that the sponsor mentioned, both of which survived First Amendment challenges. Our edits are just to also remove a couple instances of subjective language just to improve clarity and remove regulatory uncertainty for both commercial entities and for the enforcing agency, we think. Outside of what we read to be the intended scope of this law for commercial entities that knowingly publish the content targeted by this bill, which our amendment will clarify just a little bit if the sponsor is open to it, I want to highlight for the committee the alignment of our members who are indeed committed to online safety. Our members work very hard to give users the tools and software solutions to create the online experience that fits their needs and it works for their family and their children. Our member companies partner with law enforcement, educational institutions, nonprofits, government agencies, and a wide range of organizations to both provide consumer education and to protect users of all ages. This includes hiring teams to filter out child pornography, or more accurately, child sexual abuse material that is identified by the National Center for Missing and Exploited Children and report that unlawful content to the proper authorities at all levels of government. This is all a complex process and our members are very committed to this, which aligns with the intent of this bill. We simply ask that it's further aligned with the substantial work that has already been done on similar bills, just to avoid the unintended consequences and overbroad scoping. We thank you for your work on this critical issue. We thank the sponsor for their work on this, and we appreciate the opportunity to provide our feedback and apologize that it was not ready for the committee hearing.
Thank you, Ms. Barco. Please continue to work with Representative Lawley, and we'll see what comes from that. Thank you.
Thank you.
And Mr. Combs.
Good morning, Mr. Chair. Can you hear me?
We can. Please introduce yourself. We're really up against the clock, so please share with what you'd like us to know.
Thank you, Mr. Chair. I will be brief. My name is Joseph Combe. I'm an attorney and the Public Policy Director at Family Policy Alliance, and I'm here to encourage you to vote yes on HB 43. As you heard from Representative Lawley, the rise of technology has given children pretty much unlimited access to adult websites. But the bottom line is that parents have the right to direct the upbringing of their children. That includes when and how they learn about sex. So parents have that right, and age verification requirements for adults would put parents back in that rightful place of controlling whether and how their children engage with pornographic material in any instance. I want to correct something from the record earlier. The purpose of the bill is not only to protect children from the adult industry, but it's to protect them from pornography exposure wherever it is found on any website, because every exposure to pornography is a violence done to children that the state should never abide under any circumstance. So research has proven that pornography harms children. We know that over 80% of pornographic videos depict sexual violence, and almost 50% of those same videos include some kind of verbal abuse. But beyond that, the studies also show that more than half of male adolescents and almost 40% of female adolescents actually believe the lie that pornography is an accurate depiction of sex, instead of receiving age-appropriate sex education from a parent or guardian. And because they're believing that lie, they are acting it out, and they are acting out that violence among themselves. Pediatric sexual assault, where pornography exposure is the only risk factor among the underage offenders, is seeing a dramatic increase. And the research also shows that of those children who've been exposed to pornography, I think the statistic is 58% access that material unintentionally. This means that adolescents are becoming exposed and addicted to pornography accidentally through interaction with certain websites that, as we've discussed, parental involvement would have prevented. They weren't looking for the porn found them. This is how the internet works today, unfortunately. And that is proven by the fact that right now the average age of first exposure to pornography is between the ages of 7 and 13. That gives you and the state of Wyoming a clear mandate to act to protect these children. And you're not the first state to propose these bills. I think we've heard the number is 19 states across the country that have passed similar legislation. Just a further correction to the record, the 33 1/3 standard is actually the minority of those bills across the country. Most of them require states with or sites with any pornography on them at all to age verify. That has proven much more effective and much more consistent in the courts, because almost all of those laws have additionally been upheld as constitutional, and the Supreme Court seemed to signal their willingness to uphold these laws during their oral arguments last week. So just to conclude, Pornhub has indeed pulled their services from 18 of those 19 states. They say this is a form of protest, but really it's a moral statement. They believe it is a positive moral good for children to be able to access pornography without their parents' knowledge or consent. And they are signaling, in essence, that if the kids can't have porn, nobody can have porn. So to restrain a nefarious company like that that's preying upon kids, I think Wyoming ought to join the noble effort of those other 19 states around the country and implement these proven age verification requirements as soon as possible. So with that, I thank you for your time and just encourage you to vote yes on the bill.
Thank you, Mr. Combs.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. I recognize the time, so I will go very fast. But it essentially function as a recap. My name is Nathan Winters, President of the Wyoming Family Alliance, and we support this bill and appreciate the bringer for presenting it today. But it needs to be said that the First Amendment in no way permits companies to distribute obscene pornography to children. So that's the baseline I think that we have to recognize. And the state, and you'll recognize this language, Mr. Chairman, has a compelling governmental interest in safeguarding children from the harmful effects of online pornography. I'm now just gray enough to be able to start saying, I remember when. And I remember when convenience stores were made to cover pornographic magazines if they were offered for sale in those stores. And I bring this up to illustrate how in previous generations the government saw a compelling governmental interest to enforce rules that would protect children. And such provisions were considered common sense all throughout our history. And to my knowledge, they went largely unchallenged. Mr. Chairman, let me just say that today, access to pornography is far more pervasive because the internet is making laws like this very necessary. And this law is very simple. It's designed to protect children and hold the pornography companies accountable for the illicit content they distribute online. This law does that by requiring porn sites to institute reasonable and non-burdensome age verification measures. This is something, by the way, when we say non-burdensome, you've just listened to two of the world's foremost experts on this subject today. One, Mr. Corby, sitting behind me, and then Mr. Joseph Combe online, who can attest to everything I'm saying. And so this is a very sincere and well-written bill. And with that, Mr. Chairman, I would rest. Thank you.
Thank you very much. All right, others in the room wishing to testify on House Bill 43? Anybody left on Zoom? All right.
Mr. Chairman.
I think there was someone else online.
We have one more online? Bring him in. Good morning. Please introduce yourself. We are up against the clock. Tell us what we need to know, but do so briefly.
I will talk so fast. I am Christina Rangel. I am the Director of Public Policy at Exodus Cry, and I am in support of HB 43. Decades ago, the Supreme Court decided that pornography is not for children. As a survivor of sex trafficking myself, I have worked for decades in the fight to protect children from the harms of the sex industry. At no other time in human history has mainstream pornography been, one, more accessible to children and youth, and two, so graphic, hardcore, and violent. It is impossible for me to testify on the accessibility of pornography for children without talking about what modern pornography is. And to correct the further statements from the record, it is not the sexual education that we want our children to have. A recent study showed that 45% of videos from Pornhub and 35% of videos from X video scenes include at least one act of physical aggression. The most commonly used forms of aggression were gagging, slapping, and choking. Violent pornography promotes the belief that acts of sexual violence, sometimes criminal acts of violence, should be enjoyed during sex acts. These violent pornographic videos promoting criminal activities are no longer the anomalies, they are the norm. With a simple Google search of abuse porn, just one website boasts 61,459 videos under the title 18 and abused. Another popular website, rapelust.com, self-advertises on the Google homepage as, quote, watch sexual abuse rape porn now in HD. See the best sexual abuse sex videos for free, end quote. A recent study showed that over 50% of the content on Pornhub homepage was incest themed. One of the most popular channels on Pornhub that boasts over 691.4 million views is incest themed. It consists over 500 videos labeled My Perv Family. Children are recklessly accessing incest-themed family sexual abuse that erroneously demonstrates that being sexually abused by a step-sibling or step-parent should not only be tolerated, but welcomed. Pornography is the root of sex trafficking and has exponentially increased the amount of child-on-child sexual abuse. In 2020, Ruben Andre Garcia was sentenced to 20 years in prison for conspiring with the owners of Pornhub by force, fraud, and coercion to recruit young women to appear in sex videos for adult websites. Pornhub partner channel, Girls Do Porn, a top 20 most viewed channel on Pornhub, had over 680 million views. Garcia and his co-conspirators were extradited to the United States and faced 5 felony counts stemming from their operations. There are current and ongoing lawsuits against Pornhub for this very thing. One lawsuit alleges that Pornhub parent company ILO profited off of child sexual abuse material by profit sharing with sex traffickers. Jane Doe number 1 from that lawsuit was drugged, raped, filmed, and the videos were posted to Pornhub by her sex trafficker when she was only 16. Jane Doe number 2 from that lawsuit says she was forced to participate in sexually explicit videos with adults at the age of 14. These videos of her child rape were uploaded to Pornhub and remained on their website for 4 years. Another class action lawsuit filed in the Central District of California proposed that the class numbers are in the tens of thousands. The porn industry is using our children for clicks. They are making billions of dollars off of harming our children. This case is about protecting children, period. Age verification requiring minimal time and minimal information does not violate adults' constitutional right. It protects children. With 19 states having already recently passed age verification laws, the American public has made their demand very clear. It may be mainstream for adults, but it is clearly obscene for children, and it must be treated as such. It is paramount that age verification laws be allowed to do their purpose and keep children protected from online pornographic content. Thank you.
Thank you very much for that testimony this morning. Appreciate it very much. All right, with that, I'm going to close public comment. I'm going to let Representative Lawley have one last bite at the apple to wrap things up for us, and then we'll see what the committee's pleasure is.
Thank you, Mr. Chairman. This is a very real and pervasive problem. This bill seeks to address it with very clear mandates, putting the regulation, putting the responsibility on the source of this evil. And by doing that, you can tell from other testimony, it does start affecting other people indirectly. This fall may not be perfect yet. This is a shifting sand that we stand in, not legally, but effectively, in terms of effectiveness. But do not let any concerns that we might not have quite hit the mark here stop us from doing what we can in light of everything that you've just heard. I ask for your support of House Bill 43. Thank you, Mr. Chairman.
Thank you, Representative Lawley. Committee, what is your pleasure? Moved by Vice Chairman Singh, second by Representative Webb. Let's walk through the bill page by page, look for amendments. On page 1, any amendments? Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Representative Chester.
Yes, Mr. Chairman, thank you. On page 8, I would like to propose an amendment to delete paragraph G and then renumber the rest of the paragraphs accordingly. This gets to the question I asked Representative Lawley earlier. I don't think section G does anything good. I think it does. It's not necessary. I think the intent is covered by E, which does good work. G just says that lawsuits over these cases can continue over the same issue, the same claim, the same incident can never end, and that's not a good thing for the justice system. So there's nothing to do with the merits of the bill. I just think it's bad policy to allow a loser of a lawsuit to file it again and keep trying over and over again without anything different.
Is there a second? No second? Further amendments on page 8? Page 9? Page 10? Page 11. Page 12. All right, comments on the bill before we vote. Anyone?
Mr. Chairman,
Representative Filer.
I got a pretty libertarian streak in me, Mr. Chairman, and regulating, ages and what you can access, what you can't access, a lot of times goes against my libertarian streaks. But here in the United States, here in Wyoming, we also regulate age verification for alcohol, tobacco, firearms, movies, gambling, and so much more. And I also heard some comment about, libraries. Well, I believe this bill is strictly pointed at what's on the web. I don't think it has anything pointing at libraries or any of that type of content, because as we know, many libraries, even in our religious books that we have out there, have sexual content in those too. So I don't think this is going after our libraries or anything like that, or taking parents' rights away of how they want to, teach their children about, sexual education. So with that, I don't, so my libertarian side of me, I had my reservations. But with what we do already today to, help try to protect our children and our society at the young age, I'm for this bill, Mr. Chairman.
Thank you. Further comments? Representative Chester.
Thank you, Mr. Chairman. I'll be very brief. I am going to vote to advance the bill to the floor. I do have some concerns about the testimony from the librarians about how this might affect them. I'm not sure I see that in the bill. I want to study it a little more carefully. If there are some amendments that we can propose to make sure that libraries are not adversely affected, I would be happy to consider those amendments on the floor, but I will vote to advance the bill.
Further comments?
Mr. Chairman.
Vice Chairman.
Thank you, Mr. Chairman. I just wanted to note that similar restrictions have been placed in the United Kingdom, and the providers of this content did not shut down. This is a political statement by those providers in the United States, and so this does not shut down their business operation. It just merely demands accountability.
Representative Webb.
I just want to thank those involved for the effort that's been put into this of protecting our children. It's our asset and it's our future. Thank you.
Okay. With that, let's call the roll.
Representative Brady?
Aye.
Representative Brett?
Aye.
Representative Chestek?
Aye.
Representative Filer?
Aye.
Representative Kelly?
Aye.
Representative Lean?
Aye.
Representative Singh?
Aye.
Representative Webb?
Aye.
Chairman Washit?
Aye.
9 ayes.
Thank you very much. That takes us to House Bill 53. House Bill 53. So members, each year as we go into the interim, the LSO legal staff brings to our awareness those bills that were heard by the Wyoming Supreme Court that might either overtly ask the legislature to consider language or something about existing statute, or which, generally cause some awareness that maybe the legislature might want to consider these bills. And so this year, one of the bills that came up, one of the cases that came up was this Briggs decision, which was heard by the Wyoming Supreme Court. And your Judiciary Committee of the 67th took testimony over the interim, considered this case, and House Bill 53 is the result of that consideration. So what happened, I'll try and summarize this briefly. I've shared with you the dissent by Justice Couch that was issued in this case. But the case involves some police misconduct, and a failure to communicate between the investigating law enforcement officer and the prosecutor about an important point. And the Wyoming Supreme Court then created this cause of action, creating a duty of the investigating law enforcement officer to investigate non-negligently when investigating a case. So it created a duty between the officer and the suspect who's being investigated, a legal duty that didn't previously exist. And so what caused concern to the committee over the interim was the fact that in a split decision, 3 justices of the Wyoming Supreme Court created this cause of action without any statutory work by the legislature. And by doing so, we became the only state, according to Justice Couch's dissent, the only state that recognizes this specific duty between the police officer investigating a suspect and that suspect, the only state in the country. So the question before us today, and what this bill does, is abrogate that decision and say that it is the legislator's responsibility to make these sorts of decisions. Our previous bill, you might remember, itemized out different causes of action. And it's the responsibility of the legislature to identify those causes of action and not the judiciary, independent of any action by the legislature. So that's the purpose behind this bill. I know we have some in the room who want to testify about it, but that's the history behind it. I hope you've all had an opportunity to read Justice Couch's opinion, his dissent in this case, and we'll take some testimony from the room. Anyone in the room wishing to testify on House Bill 53? Mr. Thompson?
Hello, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, which is the Wyoming Association of Sheriffs and Chiefs of Police. This is an important topic for us because it puts law enforcement into a situation that we're just not familiar with and haven't been familiar with in the past. I apologize for my testimony here, but I really want to explain the full scope of this. So I want to start by saying we've seen a push across the nation in the past several years to empower those that commit crimes. Prosecutors have run for office on a pledge to not prosecute low-level offenses like drug activity and shoplifting. And we've seen the outcome in some of our larger cities and states. And we've also seen that pendulum swing back, and we've seen those same areas trying to beef up laws against drugs and things like that. And I think that's important to put this into context, because now in Wyoming, it's likely the only state in the union where a peace officer owes more deference to the suspect of a crime than to a victim due to a court ruling from 2024. And prior to 2024, we're not familiar with any lawsuit alleging or successfully alleging a negligent investigation. But since this ruling, it has been listed in the claims of at least 6 lawsuits. Wyoming statute indicates limits already in types of claims against the government. Government entities and other types of employees, non-law enforcement, can be sued for things like bodily injury, wrongful death, or property damage. But Wyoming Statute 1-39-112, which is what we're addressing here, as written today, already opens the door wide for claims against law enforcement for myriad tortious conduct, much more than the regular government employee is faced with. This also comes down to a specific understanding of negligence and how it's applied in negligent investigations. Do officers owe a duty to those it investigates? I would say absolutely. We owe a duty to everyone that we serve in law enforcement. But this concept of negligent investigations is one that still can be addressed through agency complaint processes, prosecutorial discretion, and even elections on the local level. But to hold officers to a standard unseen across the nation puts Wyoming law enforcement in an untenable situation. Directly from the dissent, we hear, it appears that every other state which has considered whether criminal suspects may sue an investigating officer for negligent investigations, has concluded he or she may not. Just to be clear, the legal definition of negligence carries a specific connotation and might be different than what we generally consider negligent behavior. According to law.com, negligence is the failure to exercise the care towards others which a reasonable or prudent person would do in the circumstances, or taking action which such a reasonable person would not. Negligence is accidental, distinguished from intentional torts, which like assault and trespass. And in summation, our biggest concern is determining what constitutes a negligent investigation when it's not even been an accepted claim across the nation. You know, law enforcement works diligently to understand court rulings from across differing courts across the nation so that we comply with the law as it's interpreted by the judicial branch across the nation. We're not asking for special protections. Law enforcement would simply like to have equal footing with other peace officers across the nation and not hesitate to investigate for fear of a lawsuit from the suspect. Thank you, Mr. Chairman. I'd be happy to answer any questions.
Thank you. Questions for witness? Representative Bratton.
Thank you, Mr. Chairman. Mr. Thompson, good to see you. So common law qualified, the common law qualified immunity defense still remains a viable defense, even if the Wyoming Governmental Claims Act says that you can sue. I just want to confirm that as I researched, spent a couple hours researching it, that is still correct.
Mr. Thompson.
Mr. Chairman, Representative Bratton, yes, qualified immunity in this ruling and in other rulings still exists for law enforcement in Wyoming.
Thank you.
Further questions? Okay, thank you. Anyone else in the room wishing to testify? Welcome this morning. Good to see you.
Thank you, Mr. Chairman. My name's Mark Aronowitz. I'm the Director of Lawyers and Advocates for Wyoming, a public interest law firm, and I will also cover the Wyoming Trial Lawyers Association today and save us a few minutes there. So we're talking about a really small part of the Wyoming Governmental Claims Act here. So a little background on the Governmental Claims Act. If you go back a few hundred years to England controlled the colonies, you couldn't sue the king. King could take your land, take your stuff, hurt you, but there was no court, no access to justice for claims against the king. And that came over. We became our own country, we had our own states, but you still couldn't sue the United States. You couldn't sue states, they were sovereigns. In 1979, the Wyoming legislature enacted the Wyoming Governmental Claims Act. And a different section that what we're looking at has some important language. That's 139-102, the purpose of the act. The Wyoming legislature recognizes the inherently unfair and inequitable results which occur in the strict application of the doctrine of governmental immunity. And then it continues, this act is adopted by the legislature to balance the respective equities between persons injured by governmental actions and the taxpayers of the state of Wyoming, whose revenues are utilized by governmental entities on behalf of those taxpayers. So we're balancing the equities, we're being fair to citizens. There's about 12 things that you can bring claims against the state for: bodily injury, death, state hospitals. One of those things is liability of peace officers. A governmental entity is liable for damages resulting from tortious conduct of peace officers while acting within the scope of their duties. This bill is just one part of the scope of the duties, the investigation duty. The decision that you may be abrogating today says, we have long held that law enforcement officers acting within the scope of their duties have a common law duty to act as reasonable peace officers of ordinary prudence under like circumstances. And that's the same general definition of negligence the gentleman just gave. Negligence is the failure to behave with the level of care that a reasonable person would have exercised under the same circumstances. So this bill effectively says you don't have to be reasonable while investigating. But lawyers aren't allowed to act negligently. Doctors aren't, teachers aren't, no professionals are. There shouldn't be a pass given here for negligent investigating. There should just be reasonable investigating, reasonable, ordinary prudence, especially if you're doing something that might lead to somebody losing their freedom. Now, simply allowing a negligent investigation claim to exist, for it to even be possible, it doesn't mean the plaintiff wins. It only means that the courtroom door isn't slammed shut. The plaintiff still has to show the defendant had a duty of care to protect the plaintiff from injury, that the defendant breached that duty with their investigation, that the plaintiff suffered an actual injury or some kind of loss, and that it was the defendant's breach and negligence that caused that injury or loss. That's not very easy to do in cases like this. So there's safeguards there. It's not like if you make the claim, you win. If you make the claim, you still have to prove it, and it's your burden to prove it as the plaintiff. A second part, we've focused on the dissent and Justice Couts, and I know some folks think Justice Couts had it right. There's two parts to this opinion. The second part of the opinion is qualified immunity, and that part says, qualified immunity protects good actors, allowing law enforcement to perform their duties without risk related to mistakes. It just imposes liability on those whose improper conduct falls outside the boundaries of qualified immunity. So plaintiff still has to prove all the elements of their claim. A defendant still gets to assert qualified immunity, which is a highly effective defense and really tough for plaintiffs to overcome. And it remains available through common law, even if immunity is otherwise waived under the Governmental Claims Act. So even if this exception still exists, qualified immunity is still there. So the two parts of the majority opinion are law enforcement officers acting within the scope of their duties owe a common law duty to the suspects in a criminal investigation to investigate as reasonable peace officers of ordinary prudence, but also law enforcement officers acting within the scope of their duties when conducting a criminal investigation are entitled to assert qualified immunity. So it is a balanced opinion. Going back to what I started with, why the Governmental Claims Act exists, it's a balance between the government and its citizens. It's inherently unfair and inequitable if you just strictly apply sovereign immunity and say, there is no claim for this. And if someone is negligent and they've acted improperly, they should be held accountable. They should be held responsible if the plaintiff can prove that that's what actually happened. So I don't think this bill is worthy of your support if you believe in government accountability and responsibility. And I don't think anyone should approve of negligence and a failure to act reasonably in any profession. So, thank you.
So, Mr. Abramovitz, there's two parts of this, right? There's the negligence, but then there's this question of duty. And I believe I'm correct that there is no duty for a peace officer on behalf of the average citizen, just anybody and everybody in the general public. And that was one of the concerns that Justice Couts brought forward, was that the whole examination of whether or not the officer had a duty to this suspect in the case, that the normal approach that the court has used previously in determining whether or not that duty exists specific to the individual case was not followed in this particular decision. And thus we ended up with a conclusion that there was in fact a duty between this officer and this citizen who is being investigated. And that the harm was also a part of this, a 7-part concerns raised in the dissent, that the harm was that the case was filed and dismissed. That was the harm claimed by the victim, right? And the peace officer doesn't have any authority over whether that case gets dismissed. Prosecutor has a role, the judicial branch has a role, and one of the concerns that Justice Couts brought out was if we open the floodgates, saying that a police officer has a duty. We have a duty to everybody we pull over for a traffic violation. We have a duty to everybody we investigate for littering. And if we do that investigation in a perceived negligent way, a case gets dismissed by the prosecutor for whatever reason, we can end up in court. And the prosecutors get hauled into court and have to give depositions. And we've heard testimony earlier this session about the shortage of prosecutors. So if you would, when you speak to this duty issue and the potential consequences that Justice Couch brought out.
Yes, thank you, Mr. Chairman. It makes me uncomfortable to disagree with you, but I will respectfully disagree with you. I think peace officers have a duty to general citizens, to suspects, to the people that they protect and serve, to everyone.
So let me interrupt there. So if you're a victim of a burglary, have I failed in my duty to protect you as a police officer assigned to your beat? There's no specific relationship between that citizen that brings a duty for the police officer to protect them from burglary or any other crime. Am I correct?
Well, yes, Mr. Chairman, you're correct, because how would a reasonable police officer know that a burglary is going to be committed? If somebody calls in, 10 times and says, there's a weird car driving around, someone's been looking through my windows with a flashlight, I'm worried I might be a victim of a burglary, and then the police do nothing on 10 calls and then the burglary happens, yeah, I would say that there is a duty. But I mean, that's an absurd hypothetical, but it shows that the duty could exist. But if there's a random crime with no foreseeability, then no, there's no duty, and you would never be able to prove the officer did anything unreasonable.
So you bring up foreseeability, and that was another point that Justice Couch brought up. Was the harm foreseeable to the officer? And the harm being the dismissal of the case. How is that foreseeable, right? And so it seemed to me that the entire approach to looking at this question of duty was not present in this case, that it wasn't done in this case. And had it been done the way Justice Couch outlined it, we'd have had a different outcome.
Mr. Chairman, I think the court went through duty for pages and then, listed the cases and said this duty has existed for a really long time. And yeah, it's a 3-2 opinion. So 3 really amazing justices saw it one way and 2 amazing justices saw it the other way. It's a close call, but it's not an obvious wrong that the majority of the Wyoming Supreme Court did here.
Thank you. Representative Lean.
Thank you, Chairman. In our fiscal note, it says that this is an indeterminable impact, and I'm wondering if in your position you can speak to the amount of cases that are filed in this jurisdiction?
Mr. Chairman, Representative Lean, I cannot speak to the fiscal impact of it. I would honestly hope that there's hardly any of these cases because there's hardly any negligent investigations. If the claim exists, there will be cases that are filed, just like cases are filed under 139, 112 now. So there'll be some impact. I just hope it's not too much.
Thank you. Representative Brad.
Thank you, Mr. Chairman. I'd like to just confirm that this isn't about a police officer pulling over somebody for speeding, that this is about a government entity being liable for damages resulting from negligent investigation. And I actually have a question, just also want to confirm that in the case, in the court case, that the harm, my understanding was that there was also harm from destruction of property because during the investigation, they refused to look at the paperwork showing the ownership, showing the type of property that was involved in this case. Is that correct?
Mr. Abramovich.
Mr. Chairman, Representative Bratton, yes, that is correct. I think the harm in this case was loss of a cultivated crop, and then also because of the investigation that led to the charges, a tremendous amount of attorney's fees fighting the case. I also think, and please correct me if I'm wrong, the plaintiff hasn't won this case. I think it went to the Supreme Court and was remanded back, but she hasn't recovered anything from the state yet, that the case is still pending. It wasn't even a remand. It was the federal court asking the Wyoming Supreme Court, what's the deal with our law here? Can you clarify it for us? So the case is still pending. The plaintiff still hasn't actually won anything by asserting this claim.
So, Mr. Abramovich, damage to property would be actionable without this negligence standard, correct?
Mr. Chairman, I think if a peace officer damaged your property under 139, 112, it should still be actionable.
Right. Okay, thank you, Mr. Abramovich. Anyone else in the room wishing to testify? Please come forward.
Thank you. I appreciate your questions.
Good
morning, Mr.
Good morning. Please have a seat, make sure the green light's on, and introduce yourself and tell us what we need to know.
Good morning, Mr. Chairman. My name is Robert Moxley. I'm an attorney in Cheyenne. I have been practicing law in Wyoming since 1979. I have grown up with the Governmental Claims Act. I represent a plaintiff who is the victim of gross negligence in investigation. My client is a completely innocent person whose identities was stolen. She changed her name, she got married and changed her name and went and got a new driver's license. Her old driver's license somehow fell into the possession of some criminals. Two criminals, a man and a woman, went to Good Guys Auto Sales here in Cheyenne, and they rented a U-Haul truck for one day pretending to be my client. And then they disappeared with the U-Haul truck. Several days later, Good Guys Auto Sales informed the Cheyenne police that they had lost a $50,000 U-Haul truck, and the Cheyenne police came to investigate, and they found that my client's old driver's license with her maiden name on it had been used as identification by this woman who was accompanied by a man in a wheelchair with no legs. They took the report. They found out that there were videos of the transaction, but they didn't look at the videos of the transaction. Instead, they went back to the police station, and after driving around town and looking at a few places for the U-Haul truck, they swore out a criminal complaint against my client under her maiden name, accusing her of stealing this U-Haul truck. About 4 days later, the U-Haul truck was found in Utah, and the people who had stolen it were living in it. And because it had been reported on the NCIC, the officers that had initiated the charges, by the way, the officers made the decision to prosecute. They drew up the paperwork that day, and they took it to the district attorney's office, and the district attorney's office simply filed charges. They were not behind the prosecution. But at any rate, what happened is they found out that these people were the thieves, and they knew that they had the truck, and they knew that my client was the wrong person. Several days later, they informed the district attorney's office. And the day that they informed the district attorney's office filed a motion to dismiss the criminal charges against my client. But the motion had not been granted that day, and that night a SWAT team appeared at my client's house and dragged her out of her house under arrest, and she was taken to jail and strip searched and terrified. She was turned loose. 5 days later, the Cheyenne Police Department issued a press release talking about my client's arrest, publishing my client's mugshot, grouping my client with 5 other criminals who had been arrested in the warrant operation, and saying that she was targeted in this warrant operation because she was a repeat offender, and they were trying to make the make the city safe from people who are thieves. My client's life has been ruined. My client has PTSD from this. My client is not the same person that she was. And it was simple. They never contacted my client. They never found my client. All they had to do was go talk to my client, and they'd have found out that it was a different person, and my client had an alibi. My client had video of her being at home at the time of the transaction, but they didn't investigate that. And it was a grossly negligent operation from start to finish. And Section 112 of the Governmental Claims Act says that police officers are liable for torts. Negligence is involved in 95% of the tort cases that come before the courts in the United States. Negligence has been fine-tuned by this legislative body over the course of my legal career, and comparative negligence has been enacted. There's statutory modifications and fine-tuning of the, assumption of risk, things like that. But negligence is the duty of a reasonable person to avoid foreseeable harm. And the harm to my client was very foreseeable, and the only thing that would have prevented the harm to my client is the lack of negligence. And so it happens. It happens here. It can happen to you. It can happen to anybody. There is lots of protection in the law, especially for police officers who have committed torts. Qualified immunity is painted with the broadest brush. It's painted with such a broad brush in federal court that this lady's cause of action against the Cheyenne police really depends on Wyoming law and on the Governmental Claims Act. And it would be a failure to hold somebody accountable who should be held accountable for this judicial decision to be reversed by the legislature. And frankly, this judicial decision, the dissent is not correct. The dissent in this saying that police don't have a duty, that is an archaic doctrine. It's called the public it's called the public duty doctrine. It says that the only duty that police have is to the public at large. That ignores the realities of modern society. Everybody has a duty to do what's right, and everybody has a duty to avoid foreseeable harm. And my client was very foreseeably, very badly harmed by the negligence of the Cheyenne police. And
Thank you. We're about out of time. So I think we got your point. Let me have one quick question for you. Would you have no cause of action in this case were it not for the Briggs decision?
I can't say that, but it would be very heavy lifting. I mean, because the facts of this case are a negligence case. I mean, there wasn't a probable cause because they had the wrong person.
So you have a false arrest case.
Yeah.
And that's actionable without the negligence decision in Briggs.
It is, but I can't say that the loss of my client's reputation is actionable without negligence. I can't say that the actual arrest of my client several days after the police knew that my client was innocent, I can't say that doesn't depend on the doctrine of negligence. And the courts protect people who are accused of negligence, and the courts protect cops.
Thank you, sir. All right. Anybody on Zoom? Anybody else in the room on this bill? With that, I'm going to close public comment. Thank you for coming today, sir. Committee, what's your preference? No motion? We'll be adjourned until Friday morning.